Welcome back. After years of debate, drafts and delays, the digital personal data protection rules are here. And yes, it's a game changer, major one actually, because this is the country's first full-fledged data protection regime, and it changes how every app, every website and every platform handles our personal data. Now, the rollout will happen in a phased manner. At the center of all this sits the new 4-member Data Protection Board of India, who will monitor compliance, decide on breaches and call out companies that slip up. So what does this mean for big platforms like Facebook, WhatsApp, Instagram, basically all social media platforms? Let's break it down. If you're under 18, platforms can't just take your personal data. They need to actually take parental consent. Next, if you haven't used an app for 3 years, the data must be deleted. Thirdly, if any data breach happens, data fiduciaries must report breaches to the Data Protection Board within 72 hours and let the data principal or the user know. Last but very important, cross-border data transfers will now face tighter restrictions. It's a challenge that is being faced in India and now is being recognized through these rules. The rules also lay out everything from how data should be stored, how consent must be obtained, and how long it can be kept. Let's quickly go across to our guest and expert joining us this morning to decode what the new rules really mean for your data, your applications, and your social media life. Going across to Khushbu Jain, advocate of the Supreme Court, joining us on the broadcast. Good morning, Khushbu. Always a pleasure speaking with you. Khushbu, with anything to do with data protection, privacy, comes a lot of complications. So let's simplify this. Let's go back to the drawing board and tell us what these rules mean for our personal private data.
Okay, so the first and foremost that comes is let's understand consent part.
Yeah.
Because, in the world of internet technology, just because it was never a tangible thing, we could never understand what's going, how that data is utilized, which all party are taking that data. And we were at the state where we would get calls, for something we have not signed up for. We would get messages where we don't understand. We would even get, the every third message on Instagram and Facebook would be an advertisement which we didn't want. Even if somebody has used my phone to browse something, it will remember that and it will start sending me those pop-ups. So it's absolutely fine to have that, but I should at least sign up. So what the law says now is consent is a paramount thing. You take the data as a data fiduciary, but not without the consent of the user. And not that old archaic way of consent, which, even lawyers could not make sense of, but a simple 1-pager or a 2-pager consent, which tells what data are you taking, for what purpose are you taking, which entities are you going to share the data, and in the event of anything, how do I exercise my rights? The rights which are guaranteed under the law, which says that I can withdraw my consent, I can erase, I can request for erasure, I can request for amendment, and so on and so forth. So this has to be in a very simple language that every data fiduciary has to inform a data principal, that is users like you and me. Now, this transparency will lead to an accountability tomorrow, because today there is zero accountability because of no transparency, and we are getting in the age of AI. We're already in the age of AI.
Yeah.
I think that's where they're saying that let the power be again in the hands of people whose data is there. At last, it's my data, my power.
Okay. Khushbu, once again, to simplify this, what kind of data are we essentially looking at? Because there is so much online data that is being fed into these digital applications. So what exact data are we talking about, A? And is this to do with how third parties, for instance, have access to data that you're feeding onto, let's say, Instagram or WhatsApp or Facebook, for instance? Is this actually to do with that third party intervention, or is it to also do with how these fiduciaries can end up using your data all by themselves?
Okay, the first question of yours, what data? See, unlike European countries, the law which says, that differentiates between sensitive data and personal data, and it has different guardrails or, requirements under it. Yeah. Indian law says nothing. Every data which is personally identifiable to the person, that is you, me, any data for that matter, even if it's a phone number and something else along with it. So every data which is personally identifiable to me is covered under the Act. The only other part is digital part of it. So no data which is not in a digital form will be part of the Act. The Act itself, if you see the name, it's Digital Personal Data Protection Act. So it says digital data which is personally identifiable to you and me. Now, coming to your second question, the second question that says that whether Facebook, whatever you search or what you do, and it has been shared with the third party, that is covered. The data which is taken by data fiduciaries and processing it and utilizing it is also covered.
Okay.
Everything is covered, which is a personally identifiable data. Now, the moment you have a data which is not personally identifiable, like it's an aggregated data that people in Delhi have this. So that's nothing to do with Khushbu Jain. It's an aggregated non-personal data. Non-personal data, it is not covered, but anything which is personally identifiable. Now, even when my search history comes, it has an understanding that this is Khushbu Jain's search history. It's part of it. Now, let's say I go and buy a car and I get calls from the loan companies which I did not sign up for. It is also covered. So I'm not saying that it will not allow these companies to share. It says take the consent from the owner. If I come
But
to your
data
house,
that you're feeding on your systems for your own access, for instance, your photographs, that's not covered, correct?
no. So again, for what am I sharing? Like, for example, anything which I make it publicly available myself, then it's a publicly available data. Then anybody else using, it's absolutely fine because I have made that data public. But if, let's say, I am putting my personal picture on social media platform, not for the public purpose, it is a private picture. But again, here also, you have to see their privacy policy and you have to see their cookie policy and you have to exercise your rights over there. Because when it comes to this data, they will ask you and granularly you can say yes or no. Only the necessary cookie or the functional cookie which is required for them to provide you services. Like, for example, if I open a bank account, I have to give my details and a KYC. I cannot request them not to utilize it or not to have this. But let's say if I'm downloading a furniture app or I'm downloading, let's say, IKEA or anything, if I say I don't want to give an access to my phone book, I don't want to give an access to my gallery or a camera or a microphone, they cannot deny me services for providing me that app. And I can absolutely take
And how will this consent be sought? Very quickly, Khushbu.
Consent be sought, okay. In a as easy manner, you take the data. So if you're taking data in a physical format and then digitizing it, a lot of times we give the form, we give the photocopy of our ID, take the consent there, digitize it. But you have to also make me understand how do I exercise my right. So it can be via your mobile apps, it can be via websites, it can be that you give me a WhatsApp, that SMS option where I get those things, you send me via email. That is all up to them. But the law says it should be as easily as you have taken the data for them and they should be aware about how do they exercise their right.
Okay, very quickly, Khushbu, one concern that digital users have is that there are a few agencies and companies that have been given the exception that you can surely access people's personal data. Now, a lot of reasons are cited: law and order concerns, national security, so on and so forth. So agencies like the Enforcement Directorate, for instance, etc., can have access to your data. Can that be a challenge going forward? Does that dilute the sensitivities attached or the relief that comes with data protection rules?
See, even if the exception is given, the exception is on the part of the rights, the obligations. But exception should not come when it comes to security of it. Because at last, a company A who's doing it for security, for providing services, for providing, let's say, research or for any matter for that matter, though it is necessary and at that time consent might play a very crucial role and they can't have a consent into it. But security at the same time plays an equal role whether company A doing it for their business purpose or company B required to do under the act and they're doing it and they're given exemptions. But the consent part, the right to recall, the right to erasure, I think those are the differentiations that are there when it comes to exempted categories.
Okay, and do you think the 12 to 18 month window for compliance which has been set while these rules were notified is a realistic figure?
Frankly speaking, I have two thoughts over it. One, this is something which ideally any company should have done that the day they have taken the data. The basics that if I take something of yours, I should ask what am I taking and why am I using it, or am I going to return it, or am I going to sell it to somebody else? That's a very basic that I'm going to take it, but I'm now this is nothing to do with you. I'm going to sell it or I'm going to do whatever I have to do. But this is an ideal which is expected out of company. They failed to do so. Now, if you take something of mine and it can have a repercussion, have security in place. Every cyber crime today happens because, even if after so much of awareness, because digital arrest, we're still fighting despite so much of an awareness for a year or more, is because these criminals have access to your information, and more the access, more easy for them to, orchestrate a plan and make you believe them. And then you're there, either for the lure part or either for the fear part of it. That's where I think the law should have been, ideally should have not come also. Right to privacy should have been good, and companies should have done that at the day one. But because it was not done, today the law says get it done. 2023 the act came in existence, and they kept saying it. Every few days there was some or the other statement released by the ministry. One should have started the homework at 2023. Now if you see today, 2 years, 18 months of time that has been given to you, it can be enough as well if you're very serious about it, and it can be if you're very scared that, oh, where do I start, how do I start. So there are very simple things to start with to understand how
this is
data
actually the start point of everything going wrong in an episode of Digital Arrest 2, for instance. So fraudsters gaining access to your private data and being able to convince you and then digitally arrest you. This is where it all begins. So really hoping for big change here. Thank you so much, Khushbu, for simplifying the story for us this morning.